recognize a fundamental right to primary education in the Right to Life under Article 21. 86 Constitutional Amendment Act of 2002. Intended that every child is a citizen of this country has the right to free education until he completes the age of 14 years. His right to education is subject to the limits of economic capacity and development of the state. In this judgment, the court overruled its earlier judgment, which declared that there was a fundamental right to education up to any level, including professional education like medicine and engineering. In this judgment, the court overruled its earlier judgment, which declared that there was a fundamental right to education up to any level, including professional education like medicine and engineering, in pursuance of Article 21. In pursuance of Article 21, the Parliament enacted the Right of Children to Free and Compulsory Education Act 2009. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education Act 2009. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education Act 2009. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education Act 2009, that is the RTE 2009. This Act seeks to provide that every child has the right to be provided for elementary education of satisfactory and equitable quality. This Act seeks to provide that every child has the right to be provided with full elementary education of satisfactory and equitable quality in a formal school that satisfies certain essential norms and standards. This legislation is anchored in the belief that the values of equality, social justice, and democracy, and the creation of just and human society. Human society can be achieved only through the provision of inclusive elementary education to all. Protection against arrest and detention. Article 22 grants protection to person who are arrested or detained. Detention is of two types, namely punitive and preventive. Punitive detention is to punish a person for an offence committed by him under trial and conviction in a court. Punitive detention and preventive detention, on the other hand, means detention of a person without trial and conviction by the court. Its purpose is not to punish a person for a past offence, but to prevent him from committing an offence in the near future. Thus, preventive detention is only for precautionary measure and based on suspicion. The Article 22 has two parts. The first part deals with the case of ordinary law. Article 22 has two parts. The first part deals with the cases of ordinary law. Article 22 has two parts. The first part deals with the cases of ordinary law, and the second part deals with the cases of preventive detention law. The Article 22 has two parts. The first part deals with the cases of ordinary law, and the second part deals with the cases of preventive detention law. The first part of Article 22 confers the following right on a person who is arrested or detained under an ordinary law: right to be informed of the grounds of arrest, right to consult and be defended by a legal practitioner, right to be produced before a magistrate within 24 hours including the journey time, and right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to any alien or a person arrested or detained under a preventive detention law. The Supreme Court also ruled that the arrest of detention in the first part of Article 22. The Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under order of a court, civil arrest, and arrest on failure to pay the income tax and deportation of an alien. The Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under order of a court. Arrest under the order of a court, civil arrest, and arrest on failure to pay income tax, not for arrest under the order of a court, civil arrest, and arrest on failure to pay the income tax and deportation of an alien. They apply only to an act of criminal or quasi-criminal nature. So punitive detention specially applies to act of criminal or quasi-criminal nature or some activity prejudicial to public interest. Punitive detention applies only to an act of criminal or quasi-criminal nature or some prejudicial or an activity that is prejudicial or an activity which is prejudicial or an activity which is it applies only to an act of criminal or quasi-criminal nature or some activity prejudicial to public interest. Punitive detention applies to some cases in which applies also to an act of criminal causing criminal nature or some activity prejudicial to public interest. The second part of Article 22 grants protection to person who are arrested or detained under a punitive preventive detention. The second part of Article 22 grants protection to person. The second part of Article 22 grants protection to person who are arrested or detained under preventive detention. This protection is available to both citizens as well as the aliens. The detention of a person cannot exceed 3 months unless an advisory court reports sufficient cause for extended detention. The board is to consist of judges of High Court. The ground of detention should be communicated to the detainee. Now, with the facts considered to be in the public interest need not be disclosed, the detainee should be afforded an opportunity to make a representation against the detention order. The detainee should be afforded an opportunity to make a representation against the detention order. The detainee should be afforded an opportunity to make a representation against the detention order. The detainee should be afforded an opportunity to make a representation against the detention order. Article 22 also authorizes the Parliament to prescribe the circumstances and the classes of cases in which a person can be detained for more than 3 months under preventive detention law without obtaining the opinion of an advisory board. Both the maximum period for which a person can be detained in any classes of cases without preventive detention law and the procedure to be followed by an advisory board in an inquiry. The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. However, this provision has not yet been brought into force. Hence, the original period of 3 months still continues. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislature. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with defense, foreign affairs and security of India. Both the Parliament as well as the state legislature can concurrently make a law of preventive detention for reasons connected with the security of a state, the maintenance of public order and the maintenance of supplies and services essential to the community. The preventive detention laws made with the Parliament are Preventive Detention Act 1950, Maintenance of Internal Security, Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, National Security Act, Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act, Terrorist and Destructive Activities Act, Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances, Prevention of Terrorism Act, that is POTA, Unlawful Activities Prevention Act, UAPA 1967 as amended in 2004, 8, 12 and 19. It is unfortunate to note that in the contain the word has been preventive detention as a integral part of the Constitution. As has been done in India, it is unknown in USA. It was resorted to Britain only during First and Second World War. In India, preventive detention existed even in the British rule. For example, the Bengal State Prisoner Regulation of 1880 and the Defence of India Act of 1939 provided for preventive detention. Right against exploitation. 23 and 24. Prohibition of traffic in human beings and forced labor. Prohibition of traffic in human beings and forced labor. Article 23 prohibits traffic in human beings, बेगार that is forced labor and other similar forms of forced labor. Trafficking को रोकता है, forced labor को रोकता है. Trafficking and forced labor is also known as बेगार and other similar forms of forced labor. Any contravention of this provision shall be an offence punishable in accordance with law. This right is available to both citizen and non-citizen. This right is available to both the citizens and non-citizens. It protects the individual not only against the state but also against the private person. The expression traffic in human being includes the buying of men, women and children, like mortal traffic in women and children, including prostitution, devdasis and slavery to one Act. The Parliament has made the Immoral Traffic Prevention Act 1956. The term begar means compulsory work without remuneration. It was a peculiar and system under which local zamindars sometimes used to force their tenants to render services without any payment. It was a peculiar and system under which local zamindars sometimes used to force their tenants to render services without any payment. In addition to because Article 23 prohibits a similar form of forced labor like bonded labor. The term forced labor means compelling a person to work against his will. The word force involves not only physical or legal but also force arising from the compulsion of economic circumstances, that is working for less than the minimum wage. In this regard, the Bonded Labor System Abolition Act 1976, the Minimum Wages Act 1948, the Contract Labour Act 1917, the Equal Remuneration Act 1946 were made. Article 23 also provides an exception to this provision and permits the state to impose compulsory service for public purpose, as for example military service or social service for which it is not bound to pay. However, in imposing such services, the state is not permitted to make any discrimination on grounds of only of religion, race, caste or class. Prohibition of employment of children in factories, etc. Article 24 prohibits employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway, but it does not prohibit their employment in any harmless or innocent work. The Child Labour Prohibition and Regulation Act 1986 is the most important law in this direction. In addition, the Employment of Children Act 1938, the Factories Act 1948, the Mines Act 1952, Merchant Shipping Act 1958, Plantation Labour Act 1951, the Motor Transport Workers Act 1951, the Apprentices Act 1961, the Variants of Workers Act 1966, and other similar acts prohibit the employment of children below a certain age. But it does not prohibit their employment in any harmless or innocent work below the age of 14 years. Below the age of 14 years, Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway. In any factory, mine, or other hazardous activities like construction work हो गया फिर railway, but it does not prohibit the employment in any harmless or innocent work. In 1996, the Supreme Court directed the establishment of a child labour rehabilitation welfare fund in which the offender employer should deposit a fine of 20,000 for each paying. It also issued direction for the improvement of education, health and nutrition of children. The Commission for Protection of Child Rights Act 2005 was enacted to provide for the establishment of a National Commission and State Commission for Protection of Child and Children Court for providing severe child offences against children or abolition of child labor. In 2006, the government banned the employment of children as domestic servant or workers in business establishment like hotel, dhaba, restaurant, shop, factories, resorts, party shop, and so on. It wanted anyone employing children below 14 years of age would be liable for prosecution and penal action. In 2006, the government banned the ये 2006 में हुआ था. In 2006, the government banned the employment of children as domestic servant or workers in business establishment like hotel, bar, restaurant, shop, factory, sport, resorts, spa, tea shop, and so on. It wanted anyone employing children below 14 years of age would be liable for prosecution and penal action. The Child Labour Prohibition and Regulation Amendment Act of 2016 amended the Child Labour Prohibition and Regulation Act 1986. It has renamed the Principal Act as Child and Adolescent Labour Prohibition and Regulation Act 1986. Right to freedom of religion, freedom of conscience, and free profession, practice, and propagation. सबसे पहले freedom of conscience, profess, practice, and propagate. Profess, practice, and then propagate. Profess, practice, and then propagate. Profess, practice, and then propagate. Freedom of conscience, enough freedom of an individual to mold the relation with God or creation in whatever way he desires. Freedom of conscience, freedom to profess, practice, and propagate. Freedom to profess, practice, and propagate. Right to profess, declaration of one's religious belief and faith openly and freely. Right to practice, performance of beliefs, worship, ritual ceremonies, and exhibition of beliefs and ideas. Right to propagate, transmission, and dissemination of one's religious beliefs to others, or exposition of the tenets of one's religion, but it does not include a right to convert another person to one's own religion. Forcible conversion impinges on the freedom of conscience guaranteed to all the persons alike. Article 25, freedom of conscience, freedom to profess, practice, and propagate. From the above, it is clear that Article 25 covers not only religious belief doctrines but also religious practices such as rituals. Moreover, these rights are available to all persons, citizens as well as non-citizens. These rights are subject to public order, morality, health, and other provisions relating to fundamental rights. Further, the state is permitted to regulate or restrict any economic, financial, political, or other secular activity associated with religious practice and provide for social welfare and reform through open Hindu religious institution of a public character to all classes and sections of Hindus. However, these rights are subject to public order, morality, health, and other provisions relating to fundamental rights. Further, the state is permitted to regulate or restrict any economic, financial, political, or other secular activity associated with religious practice, provide for social welfare and reform, or through open Hindu religious institution of a public character to all classes and section of Hindus. Article 25 also contains strict regulation while wearing and carrying of kirpan is to be included in the profession of the Sikh religion. Wearing and carrying of kirpan is to be included in the profession of the Sikh religion. And two, the Hindus in this context include Sikh, Jain, and Buddhist. Freedom to manage religious affairs. According to Article 26, freedom to manage religious affairs. Every religious denomination or any of its sections shall have the following right. According to Article 26, every religious denomination or any of its sections shall have the following right. According to Article 26, every religious denomination or any of its sections shall have the following right. Right to establish and maintain institution for religious and charitable purpose. Right to manage its own affairs in matter of religion. Right to own and acquire movable and immovable property. Right to administer such property in accordance with law. Article 25 guarantees right of individual, while Article 26 guarantee right of religious denomination or their section. In other words, Article 26 protects collective freedom of religion like the right, and Article 25, the right and Article 26 are also subject to public order, morality, and health, but parts of the fundamental right. The Supreme Court held that a religious denomination must satisfy three conditions. The Supreme Court had held that a religious denomination must satisfy total three conditions. It should be a collection of individuals who have a system of belief. The Supreme Court held that a religious denomination must satisfy three conditions. The Supreme Court held that a religious denomination must satisfy three conditions. That it should be a collection of individuals who have a system of belief, doctrines, which regard as conducive to their spiritual well-being. It should have a common organization, and it should be designed by a distinctive name. Under the above criteria, the Supreme Court held that Ramakrishna Mission and Ananda Marga religious denomination within the Hindu religion. It also held the Aurobindo Society is not a religious denomination. Ramakrishna Mission and Ananda Marga, Ramakrishna Mission and the Ramakrishna Mission and the Ananda Marga, Ramakrishna Mission and the Ananda Marga, Ramakrishna Mission and the Ananda Marga. Ramakrishna Mission and Ananda Marga are religious denomination. Next is freedom from taxation. Freedom from taxation for promotion of a religion. Freedom from taxation for promotion of a religion. Article 27 lays out that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion. Article 27 lays out that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion. Or religious denomination. In other words, the state should not charge the public money collected by way of tax for the promotion or maintenance of any particular religion. This provision prohibits the state from favoring, patronizing, and supporting one religion. This means that the taxes can be used for the promotion or maintenance of all religion. This means that the taxes can be used for the promotion or maintenance of all religion. This means that the taxes can be used for the promotion or maintenance of all the religion. This means that the taxes can be used for the promotion or maintenance of all the religion. This provision prohibits only levy of a tax and not a fee. This is because the purpose of a fee is to control secular administration of a religious institution and not to promote or maintain religion. Thus, a fee can be levied on pilgrims. A fee can be levied on pilgrims to provide them some special services, safety measures. Similarly, a fee can be levied on religious endowments for meeting the regulation expenditure. Freedom from attending religious instructions. Freedom from attending religious instruction under Article 20. Under Article 28, no religious instruction shall be provided in any educational institution. Under Article 28, no religious instruction shall be provided in any educational institution. Freedom from attending religious instruction. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of state fund. However, this provision shall not apply to educational institution administered by the state but established under an endowment or trust requiring imparting of religious instruction in such institution. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of state fund. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of the state fund. Under Article 28, no religious instruction. Under Article 28, no religious instruction shall be provided in any education institution wholly maintained out of the state fund. Further, no person attending any education institution recognized by the state or receiving aid out of state fund shall be required to attend any religious instruction or worship in that institution without this consent. In case of a minor, the consent of his guardian is stated. Thus, Article 20 distinguishes between further of education institution wholly maintained by the state, institution administered by the state but established under any endowment or trust, institution recognized by the state, an institution receiving aid from the state. In a, religious instruction is completely prohibited, while prohibited religious instructions is permitted. In C and D, religious instruction is permitted on a voluntary basis. That is, institution recognized by the state and institution receiving aid from the state. These are इसमें इन दोनों में on a voluntary basis. Religious instruction is permitted on a voluntary basis. Cultural and education right, that is protection of interest of minority. Protection of interest of minority. Article 29 provides that any section of the citizen residing in any part of the India having a distinct language, script or culture of its own shall have the right to conserve the same. Article 29 provides that any section of the citizen residing in any part of India having a distinct language, script or culture of its own shall have the right to conserve the same. Further, no citizen shall be denied admission into an education institution maintained by the state or receiving aid out of state fund. Further, no citizen shall be denied admission into an education institution maintained by the state or receiving aid out of state fund on ground only of religion, race, caste or sex, language. Further, no citizen shall be denied admission into an education institution maintained by the state or receiving aid out of state fund on ground only of religion, race, caste or language. Protection of interest of minority. Any section of the citizen residing in any part of India having a distinct language, script or culture of its own shall have the right to conserve the same. Protection of interest of minority. Protection of interest of minority, and it talks about any section of minority in the society. Article 29. The first provision protects the right of a group, while the second provision guarantees the right of a citizen as an individual irrespective of the community to which he belongs. Article 29 grants protection to both religious minorities as well as linguistic minorities. Article 29 grants protection to both the religious minorities as well as the linguistic minorities. और ये religious as well as linguistic minority दोनों की बात करता है. However, the Supreme Court held that the scope of this article is not necessarily restricted to minority only, as it is commonly assumed to be. This is because of the use of the word section of citizen in the article that include minority as well as majority. The Supreme Court also held religious as well as the linguistic. It will be religious minority as well as the linguistic minority. The Supreme Court also held that the right to conserve the language includes the right to educate for the protection of the language. Hence, the political speeches or promises made for the conservation of the language of a section of the citizen does not amount to corrupt practice under the RP Act of 1951. Right of minority to establish and administer education institution. Article 30 grants the following right to minority, whether religious or linguistic. All minorities shall have the right to establish or administer education institution of the choice. All the minorities shall have the right to establish and administer education institution. All the minorities shall have the right to establish and administer education institution of their choice. All the minorities shall have the right to establish and administer education institution of their choice. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority education institution shall not restrict the right guaranteed to them. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority education institution shall not restrict or abrogate the right guaranteed to them. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority education institution shall not restrict or abrogate the right guaranteed to them. This provision was added with the 44th Amendment Act of 1978 to protect the right of minority in this regard. The Act deleted the right to property as a fundamental right. That is Article 31. In granting it, the state shall not discriminate against any education institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious and linguistic, and does not extend to any section of the religion. However, the term minority has not been defined anywhere in the Constitution. Protection of interest of minorities and right of minority. पहले है protection of interest of minority and second is the right of minorities to the right of the minorities to establish the right of the minority to establish and administer education institution. Next is however the term minority has not been however the term minority has not been defined anywhere in the constitution. However, the term minority has not been defined anywhere in the constitution. The right under Article 30 also includes the right of the minority to get education to its children in its own language. Minority education institutions are of three types. Institution that seek recognition as well as aid from the state. Institution that seek only recognition from the state and not aid. Institution that neither seek recognition nor aid from the state. The institution of first and second type are subject to the regulatory power of the state. The institution of the first and second type are subject to the regulatory power of the state with regard to syllabus, restriction of academic standard, discipline, sanitation, employment of teaching staff, and so on. The institution of third type are free to administer their affairs. The institution of third type are free to administer their affairs but subject to operation of general laws like contract laws, labor laws, industrial law, tax law, economic regulation, and so on. In a judgment delivered in the Secretary of Malankara Syrian Catholic College, case 2007, the Supreme Court has summarized the general principle relating to establishment and administration of minority education institution in the following way. Malankara Syrian Catholic College, the right of minority to establish and administer educational college. The right of minorities to establish and administer educational institutions of their choice comprises the following: right to choose a governing body in whom the founders of the institution have faith and confidence to conduct and manage the affairs of the institution, to appoint teaching staff, that is, teachers, lecturers, and headmasters, principals, and also non-teaching staff, and to take action if there is dereliction of duty on the part of any of its employees to admit eligible students of their choice, and to set up a reasonable fee structure to admit eligible students of their choice, and to set up a reasonable fee structure to use its properties and assets for the benefit of the institution. The right conferred on minority under Article 30 is only to ensure equality with the majority and not intend to place the minority in a more advantageous position in relation to the majority. If in comparison there is no reverse discrimination in favor of minority, the general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc. applicable to all will equally apply to minority institution also. The right to establish and administer education institution is not absolute, nor does it include the right to maladminister. There can be regulatory measure for ensuring education character and standards and maintaining academic excellence. There can be checks on administration as are necessary to ensure that the administration is efficient and sound so as to serve the academic needs of the institution. Regulation made by the state concerning generally the welfare of student teachers, regulation linked on eligibility criteria and qualification for appointment as also condition of service of employees, both teaching and non-teaching, regulation to prevent exploitation or oppression of employees, and regulation prescribing syllabus and curriculum of study. The right to establish and administer educational institution is not absolute. The right to establish and administer the educational institution is not absolute, nor does it include the right to maladminister. There can be regulatory measure for ensuring education curriculum standard and maintaining academic excellence. There can be checks on administration as are necessary to ensure that the administration is efficient and sound need of the institution. Regulations made by the state concerning generally the welfare of students and teachers, regulation linked on eligibility criteria and qualification for appointment, as also condition of service of employees for teaching and non-teaching. Regulation to prevent exploitation or oppression of employees, and regulation prescribing syllabus and curriculum of study fall under this category. Such regulation do not in any manner interfere with the right under Article 30 Clause 1. Subject to the eligibility condition qualification prescribed by the state being met, the unaided minority education institution will have the freedom to appoint teachers, lecturers by adopting an rational procedure of selection. Extension of aid by the state does not alter the nature and character of the minority education institution. The condition can be imposed by the state to ensure proper utilization of the aid without power diluting or abridging the right under Article 30 Clause 1. Next is right to constitutional remedies. A mere declaration of a fundamental right in the Constitution is meaningless, useless and worthless without providing an effective machinery for their enforcement. If and when they are violated, hence Article 32 confers the right to remedies for the enforcement of a fundamental right of an aggrieved person. Article 32 confers the right to remedies for the enforcement of the fundamental right of an aggrieved person. In other words, the right to get the fundamental right protected is in itself a fundamental right. And this means the fundamental right real. That is why Dr. Ambedkar called Article 32 as the most important article of the Constitution. An article without which the Constitution would be nullified. It is the very soul of the Constitution, the very heart of the Constitution. It is the very soul of the Constitution, the very heart of the Constitution. And the Supreme Court has ruled that Article 32 is the basic feature of the Constitution, as it cannot be agreed or taken away even by way of an amendment to the Constitution. It contains the following four provisions: the right to move the Supreme Court by appropriate proceeding for the right for the enforcement of the fundamental right is guaranteed. The Supreme Court shall have power. The Supreme Court. The Supreme Court shall have power to issue directions or orders or for the enforcement of any of the fundamental rights. The Supreme Court shall have powers or issue directions. The Supreme Court shall have power to issue directions or orders or for the enforcement of any of the fundamental rights. The Supreme Court shall have power to issue directions or orders or writs for the enforcement of any of the fundamental rights. This writs issued may include habeas corpus, mandamus, provisions, certiorari, and governor. The Parliament can empower any other court to issue direction, orders, and writs of all kinds. However, this can be done without prejudice to the above power conferred on the Supreme Court. Any other court here does not report High Court because Article 226 has already conferred these powers on the High Court. Parliament can empower any other court to issue directions, orders, and writs of all kinds. Parliament can empower any other court to issue direction, order, and writs of all kinds. However, this can be done without prejudice to the above power conferred on the Supreme Court. Article 226 has already conferred these powers on the High Court. The right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Because the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental right during a national emergency. It is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental right of the citizen. It has been vested with the original and wide power for that purpose. Original because an aggrieved citizen can directly go to the Supreme Court. Original QM because an aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal. Wide because its power is not restricted to issuing of order or direction but also writs of all kind. The purpose of Article 32 is to provide a guaranteed, effective, expeditious, and expensive and severe remedy for the protection of the fundamental right. Only the fundamental right guaranteed by the Constitution can be enforced under Article 32 and not any other right like non-fundamental constitution, statutory right, customary right, and so on. The possession of a fundamental right is for the sign on and for the exercise of the right. Article 32. The violation of the fundamental right is an important part of the exercise of the right conferred by Article 32. In other words, the Supreme Court under Article 32 cannot determine a question that does not involve FR. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or legislation unless it directly infringes any of the fundamental right. In case of the enforcement of fundamental right, the jurisdiction of the Supreme Court is original but not exclusive. In case of the enforcement of the fundamental right, in case of the enforcement of the fundamental right, the jurisdiction of the Supreme Court is original but not exclusive. In case of the enforcement of the fundamental right, the jurisdiction of the Supreme Court is original but it is not exclusive. In case of the enforcement of the fundamental right, the jurisdiction of the Supreme Court is original but it is not exclusive because High Court under Article 226 also has power to issue writs. It is concurrent with the jurisdiction of the High Court under Article 26. It was original power in the High Court to issue direction, orders, and writs of all kinds for the enforcement of the fundamental right. It means when the FR petitioner violated the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Since the right guaranteed by Article 32, that is the right to move to the Supreme Court where a fundamental right is infringed, is in itself a fundamental right. The availability of alternate remedy is no bar to relief under Article 32. However, the Supreme Court has ruled that where relief through High Court is available under Article 26, the aggrieved party should first move the High Court. The aggrieved party first move the High Court. Its types and scope. This is all about the types of writs. The Supreme Court under Article 32 and High Court under Article 226 can issue the writ of habeas corpus, mandamus, prohibition, certiorari, and government. Further, the Parliament under Article 32 can empower any other court to issue these writs. Further, the Parliament under Article 32 can also empower other courts other than the High Courts to issue writs. Since no such provision has been made so far, only the Supreme Court and the High Court can issue the writs and not any other court. Before 1950, only the High Courts of Calcutta, Bombay and Madras had the power to issue the writs. Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law, where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king, who was and is still described as the fountain of justice. Later, the High Court started issuing these writs as an extraordinary remedies to uphold the rights and liberties of the British people. The jurisdiction of the Supreme Court differs from that of the High Court in three respects. The jurisdiction of the Supreme Court differs from that of a High Court. The jurisdiction of a Supreme Court differs from that of the High Court in the following respects. In the following three respects. That is, the Supreme Court can issue writs only for the enforcement of fundamental right. The Supreme Court can issue writs only for the enforcement of fundamental right. The Supreme Court can issue writs The Supreme Court can issue writs only for the enforcement of the fundamental rights, whereas the High Court can issue writs not only for the enforcement of the fundamental right but also for any other purpose. Supreme Court can issue writ only for the enforcement of the fundamental right, whereas the High Court it can issue writ not only for the enforcement of the FR but also for any other purpose. The expression for any other purpose refers to the enforcement of an ordinary legal right. Thus, the jurisdiction of the Supreme Court in this respect is narrower than that of the High Court, because it can issue writ only when any of the law infringes upon the fundamental right. The Supreme Court can issue writs against a person or government throughout the territory of India, whereas the High Court can issue writ against a person residing or against a government or authority located within its jurisdiction only or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. Then the territorial jurisdiction of the Supreme Court for the purpose of issuing writ is wider than that of the High Court. A remedy under Article 32 is in itself a fundamental right, and hence Supreme Court may not refuse to exercise its jurisdiction. On the other hand, remedy under Article 226 is discretionary, and hence a High Court may refuse to exercise its jurisdiction. Remedy under Article 226 is discretionary. मतलब writ jurisdiction under Article 226 is discretionary, and hence a High Court may refuse to exercise its jurisdiction. Article 32 does not merely confer power on the Supreme Court as Article 226 does on a High Court to issue writs for the enforcement of fundamental right or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as the defender and guarantor of the fundamental right. Now we will proceed to understand the meaning and scope of different kind of writ mentioned in Article 32 and 226 of the Constitution. So first is the habeas corpus. It is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person. It is issued by a court to a person who has detained another person. It is issued by a court to a person who has detained another person to produce the body of the later before it. It is an order issued by a court to a person who has detained another person to produce the body of the later. So basically it is an order issued by the court to a person. It is an order issued by a court to a person who has detained another person. It is the order which is given by the court to a person who has detained another person to produce a body of the later before it. The court then examines the cause and legality of detention. It puts that the detained person free if the detention is found to be illegal. Thus, the writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. Habeas corpus it can be issued against both the public authorities as well as the private individuals. It can be ये पब्लिक अथॉरिटीज़ के लिए भी हो सकता है एज वेल एज प्राइवेट इंडिविजुअल के लिए भी हो सकता है. द रिट ऑफ habeas corpus can be issued against both public authorities as well as private individual. The writ of habeas corpus can be issued against both the public authorities as well as private individual. The writ of habeas corpus can be issued against both the public authorities as well as the private individual. The writ of habeas corpus can be issued against both the public authorities as well as private individual. The writ of habeas corpus can be issued against both the public authorities as well as the private individual. The writ of habeas corpus can be issued against both the private individual as well as the public authority. Threat on the other hand is not issued where the detention is lawful. The proceeding is for contempt of a legislation of a court. Detention is by competent court and detention is outside the jurisdiction of the court. Habeas corpus, public authorities and private individual दोनों के लिए होता है. For the public authorities and private individual mandate, it literally means that as we command. It literally means we command. It is a command issued by the court to a public official. We command issued by a court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body. It can also be issued against any public body, corporation, inferior court or tribunal or government for the same purpose. The writ of mandamus cannot be issued against the it cannot be issued against a private individual or body. Private individual or body के अगेंस्ट नहीं कर सकते हैं. टू अ पब्लिक ऑफिशियल asking पब्लिक बॉडी, कॉर्पोरेशन, इंफीरियर कोर्ट, ट्रिब्यूनल, गवर्नमेंट हो सकता है. इट कैन बी इशूड against both the public authorities as well as private individual. Public authority और private individual दोनों कर सकते हैं. और it can also be issued against any public body, corporation हो गया, inferior court हो गया, tribunal हो गया and government for the same purpose. Mandamus cannot be issued against a private individual or body to enforce departmental instruction that does not possess statutory force when the duty is discretionary, not mandatory, to enforce a contractual basis against the President of India or state government and against the Chief Justice of a High Court against the judicial capacity. यहाँ पे बोला गया against the Chief Justice of a High Court and against the Chief Justice of a High Court acting in judicial capacity and against the President of India or the state government. Prohibition to forbid literally means to forbid. It is issued by a higher court, a lower court, or tribunal. It is issued by a higher court. It is issued by a higher court to a lower court or tribunal to prevent the data from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus that there is activity, the prohibition that there is inactivity, the writ of prohibition can be issued only against judicial and quasi-judicial authorities. It can be issued only against judicial and quasi-judicial authorities. It can be issued only against the judicial as well as the quasi-judicial. It is issued by a higher court to a lower court or tribunal. It is issued by a higher court. Prohibition. It is issued by a higher court to a lower court. Literally it means to forbid. It is issued by a higher court to a lower court. Literally it means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus, the direct activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It can be issued only against judicial and quasi-judicial authority. It is not available against administrative authority, legislative body and private individual or bodies. The writ of prohibition can be issued only against judicial and quasi-judicial authority. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative body and private individual or bodies. Literally it means to forbid. It is issued by a higher court. Means to forbid. It is issued by a higher court or lower court or a tribunal to prevent the data from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus directs activity, the prohibition directs inactivity. The right of prohibition can be issued only against judicial and quasi-judicial authority. It is not available against administrative authority, legislative body and private individual or bodies. Certiorari in the literal sense, it means to be certified or to be informed. Certiorari means to be certified or to be informed. Certiorari means to be certified and to be certified and to be informed. It is issued by a higher court to a lower court. It is willing either to transfer a case pending with the later to itself or to squash the order of the later in a case. Latter in a case, it is issued on the ground of excess of jurisdiction, lack of jurisdiction. To be certified or to be informed, thus unlike prohibition which is only preventive, certiorari is both preventive as well as curative. Previously, mandamus होता है ये it directs activity, prohibition directs inactivity, and prohibition which is only preventive. Certiorari is both preventive as well as curative. Previously, the writ of certiorari could be issued only against judicial and quasi-judicial authority and not against administrative authority. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting right of individual. So it could be issued only against judicial, quasi-judicial authorities, and in 1991 can be issued even against administrative authorities affecting the right of individual. Like prohibition, certiorari is not available against legislative bodies and private individual bodies. Like prohibition, certiorari is also not available against the legislative bodies and private individual bodies. Mandamus, that is we command. So prohibition and prohibition, that is to forbid. It is used to prevent the later from exercising its jurisdiction, and it can be issued only against the quasi-judicial and quasi-judicial bodies. The writ of prohibition can be issued only against judicial and quasi-judicial authority. The writ of prohibition can be issued only against judicial and quasi-judicial authority. The writ of prohibition can be issued only against judicial and quasi-judicial authority. Habeas corpus, mandamus, prohibition, certiorari to be certified or to be informed. It is issued by a higher court to a lower court or tribunal, either to transfer a case pending with the later to itself or to squash the order of the later in a case. Either to transfer a case pending with the later to itself or to squash the order of the later in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. This, unlike prohibition, which is only preventive, certiorari is both preventive. Certiorari is both preventive as well as it is curative. Certiorari is both preventive as well as curative. Judicial and quasi-judicial authorities along with administrative authorities affecting right of individual. Like prohibition, certiorari is also not applicable against legislative bodies and private individual or both private individuals or bodies. Quo warranto, in the literal sense it means by what authority or warrant. In the literal sense, by what authority or warrant it is issued by the court, inquiring into the legality of a claim of a person to a public office and that prevents illegal usurpation of a public office by a person. That it can be issued only in case of a substantive public office of a permanent character created by statute or by the constitution. It cannot be issued in cases of ministerial office or private office. Sought by any interested person and not necessarily by the aggrieved person. This can be sought by any interested person and not necessarily by the aggrieved person. In the literal sense, meaning by what warrant, by what authority or warrant it is issued by the court to inquire into the legality of a claim of a person to a public office. It is issued by the court to inquire into the legality of a claim of a person to a public office. Hence, it prevents illegal usurpation of a public office of a person. That it can be issued only in cases of a substantive public office of a permanent character created by statute or by constitution. It cannot be issued in case of ministerial office or private office. Unlike the other four, this can be sought by any interested person and not necessarily by the aggrieved person. Armed Forces and Fundamental Rights. Armed Forces and Fundamental Rights. Article 33 empowers Parliament to restrict or abrogate the FR of the members of the Armed Forces Paramilitary Forces. Article 33 empowers the Parliament to restrict or abrogate the fundamental right of the members of the Armed Forces, Paramilitary Forces, Police Forces, Intelligence Agencies, and Reserve Forces. The objective of this provision is to ensure the proper discharge of the duties and the maintenance of discipline among them. The powers to make laws in Article 33 is conferred only on Parliament and not on state legislature, and it can be done only by the Parliament. Any such law made by Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental right. Any such law made by Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental right. Any such law made by Parliament cannot be challenged Force Act, the Police Forces Restriction of Right Act, and the Border Security Force Act, and so on. They impose a restriction on the freedom of speech, right to home association, right to be member of trade union or political association, right to communicate with the press, right to attend public meeting or demonstration, etc. The expression members of the armed forces also cover such employees of the armed forces as barbers, carpenters, mechanics, cooks, chaukidas, boatmakers, tailors who are non-combatants. A parliamentary law enacted under Article 33 can also exclude the court-martial tribunal established under the military law from the jurisdiction of the Supreme Court and the higher court so far as enforcement of FR is concerned. Martial law is a national emergency. Martial law, it affects only fundamental rights. National emergency, it affects not only fundamental rights but also center-state relation. Distribution of revenues and legislative powers between center and states and may extend the tenure of the parliament. National emergency, it affects not only the fundamental right but also the center-state relation. Distribution of revenues and legislative power between center and state and may extend the tenure of the parliament. Martial law, it suspends the government and ordinary law code. Breakdown of law and order due to any reason can be imposed only in 3 from war, external aggression, or armed rebellion. It is imposed in some specific area of the country. It is imposed either in the whole country. It is imposed either in the whole country or in a part of it. It has no specific provision in the constitution. It is implicit. It has specific and detailed provision in the constitution. It is explicit. It is explicit. I will answer all your questions in a while. अभी approximately 3 to 4 pages बचे हुए हैं तो उसे पढ़ के फिर मैं रिप्लाई करूँगी. Martial law and fundamental right, Article 34. Article 33 gives the power to the Parliament to abridge or abrogate any of the FR for the members of the armed forces, paramilitary forces, or police forces. Provide for the restriction. Article 34 provides for the restriction on the fundamental right while martial law is enforced in any area. Article 34 provides for the restriction on the fundamental right while martial law is enforced in any area within the territory of India by the Parliament to indemnify any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law was enforced. The Parliament can also invalidate any sentence passed empowers the Parliament comes into force to indemnify any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law was enforced. The Parliament can also validate any sentence passed, punishment inflicted, feature ordered or other act done under martial law in such area. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the FR. The concept of martial law has been borrowed in India from the English common law. Parliament abridges. Again, the martial law was not that the Parliament abridges or replicates any of the fundamental rights. The concept of martial law has been borrowed in India from the English common law, and martial law, it has been taken from English law, that is from. Now, the expression martial law has not been defined anywhere in the Constitution. martial law has been borrowed in India from the English common law. However, the expression martial law has not been defined anywhere in the constitution. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary law. It thus implies the suspension of ordinary law in the government of military tribunal. It is different from the military law that is applicable to the armed forces. There is also no specific or express provision in the constitution that authorizes the executive to declare martial law. However, it is implicit in Article 34, under which martial law can be declared in any territory of India. The martial law is imposed in extraordinary circumstances like war, invasion, infection, rebellion, reorder, any violent resistance to law. Its justification is to repel force by force for maintaining or restoring order in the society. During the operation of martial law, the military authorities are vested with abnormal powers to take all these steps. They impose restriction and regulation on the rights of the civilian and can punish the civilians and even condemn them to death. The Supreme Court held that the declaration of martial law does not ipso facto result by the very fact result in the suspension of the writ of habeas corpus. And the declaration of martial law under Article 34 is different from the declaration of national emergency under Article 352. The differences between the two are summarized in Table 7.3. Affecting certain fundamental rights. Article 35 lays down the power to make laws. Article affecting certain fundamental rights. Article 35 lays down that power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament. Article 35 lays down that the power to make laws to give effect to certain specific fundamental rights shall vest only in the Parliament and not in state legislature. This provision ensures that there is uniformity throughout India with regard to the uniform nature of those fundamental rights and punishment for their infringement in this direction. Article 35 contains the following provision: the Parliament shall have and the legislature of a state shall not have powers to make laws with respect to the following matter: prescribing residence as a condition for certain employment, that is affecting certain fundamental rights. Article 35 lays down the power to make laws in the hands of the Parliament so that a uniformity can be maintained throughout the country. Prescribing residence as a condition for certain employment or appointment in a state or UT or local authority or other authority, that is Article 16. Other authority empowering courts other than the Supreme Court. Empowering courts other than the Supreme Court and the High Court to issue direction orders and crimes for the enforcement of fundamental right. Empowering courts other than the Supreme Court and the High Court. Empowering courts other than the Supreme Court and the High Courts to issue direction order and writ of organ for the enforcement of the fundamental right, and it comes under the jurisdiction of the Parliament. And this is important because Parliament can empower any other court to issue direction order and writ of all kinds, restricting or abrogating the application of fundamental right to members of armed forces, police forces, indemnifying any government servant or any other person or any actor during the operation of martial law in any area. Next is Parliament shall have and the legislature of a state shall not have power to make laws for prescribing punishment for those acts that are declared to be offences under the fundamental right. These include the following: Parliament shall have powers to make laws for prescribing punishment for those acts that are declared to be offences under the fundamental right. These include anti-charity, traffic in human being and forced labour. Further, the Parliament shall have the commencement of the Constitution make laws for prescribing punishment for the above act. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishment for the above act, thus making it obligated on the part of the Parliament to enact such laws. Any law enforced at the commencement of the Constitution with respect to any of the matters specified upon is to continue in force until altered or repealed or amended by the Parliament. It should be noted here that Article 35 extends the competence of the Parliament to make law on the matters specified above, even though some of those matters may fall within the sphere of the state legislature. Present Article 35 extends the competence of the Parliament to make law on matters specified above, even though some of those matters may fall within the sphere of the state legislature, that is the state list. Present proposition of right to property. Originally, the right to property was one of the 7 fundamental rights under Part 3 of the Constitution. It was deleted by Article 19, Clause 1, Subclause F. मतलब Article 19 1 F में दिया गया था and Article 31. Article 19(1) guaranteed to every citizen the right to acquire, hold and dispose of property. Acquire, hold and dispose of Article 19(1) guaranteed to every citizen the right to acquire, hold and dispose of property. Article 31 on the other hand, Article 19(1) guaranteed to every citizen the right to acquire, hold and dispose of property. Article 21 guaranteed to every citizen the right to acquire, hold and dispose of property. Article 31 on the other hand, guaranteed to every person whether citizen or non-citizen the right against deprivation of his property. Article 31 provided the right against deprivation of his property, provided that no person shall be deprived of his property except by the authority of law. It empowered the state to acquire or requisition the property of a person on two conditions. It should be for public purpose and it should provide for payment of compensation amount to the owner. Since the commencement of the constitutional effort, the property has been the most controversial. It has caused confrontation between the Supreme Court and the Parliament. It has led to a number of constitutional amendments, that is first 4, 7, 25, 39, 40 and 42nd. Through this amendment, Article 31A, 31B, 31C have been added and modified from time to time to nullify the effect of Supreme Court judgment and to protect certain laws from being challenged on the ground of contravention of fundamental rights. Most of the litigation centered around the obligation of the state to pay compensation for requisition of private property. Therefore, the 44th Amendment Act of 1978 abolished the right to property as a fundamental right by repealing Article 19(1)(f) and Article 31 from Part 3rd. Instead, the Act introduced a new article, Article 300(a). In Part 12, under the heading Right to Property, it provides that no person shall be deprived of his property except by authority of law. Thus, the right to property still remains a legal right. Thus, the right to property still remains a legal right or constitutional right. Thus, the right to property still remains a legal right or a constitutional right. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. The right to property is a legal right as distinct from the fundamental right as a following implication. It can be regulated, that is curtailed, abridged or modified without constitutional amendment or by an ordinary law of Parliament. Then next is it protects private property against executive action but not against legislative action. It protects private property against executive action but not against legislative action. In case of violation, the aggrieved person cannot directly move the Supreme Court under Article 30 to right to constitutional remedies, including that for its enforcement, he can move the High Court under Article 226. No guaranteed right to compensation in case of acquisition or requisition of the private property by the state. No guaranteed right to compensation. Though the fundamental right to property under Part 3 has been abolished, Part 3 still carries the provision which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. These two cases, compensation has to be paid when the state acquires the property of a minority education institution. Article 30, when the state acquires the land held by a person under his personal cultivation, the land is within the statutory ceiling limit. When the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limit. The first provision was added by the 44th Constitutional Amendment Act of 1978, that is compulsory compensation milega under Article 30. It is added by 44th Constitutional Amendment Act of 1978. It is added by the 44th Constitutional Amendment Act of 1978. When the second provision was added by the 17th Amendment Act of 1964. That is when the state acquires the agricultural land of a person, land under person under his personal cultivation, and the land is within the statutory ceiling limit. So the very first provision was added by the 44th Constitutional Amendment Act, and the second provision was added by the 17th Constitutional Amendment Act of 1964. Further, Article 31A, 31B and 31C have been retained as exception to the fundamental right. 31A, 31B and 31C have been retained as exception to the fundamental right. Saving of laws providing for acquisition of estates, etc. Article 31A saves 5 categories of laws from being challenged. Further, Article 31A, 31B, 31C have been retained as exception to the fundamental rights. Article 31A, 31B, 31C exceptions to the fundamental rights. 31A saves 5 categories of laws. Here Article 31A safeguards the 5 categories of laws from being challenged and invalidated on ground of contravention of the fundamental right conferred by Article 40 and Article 90. They are related to agriculture, land reform, industry and commerce, and include the full acquisition of estate and related right by the state, taking over the management of properties by the state, आर्टिकल 31A 5 टाइप्स के लॉज को बचाता है फ्रॉम लेटिंग बीन चैलेंज ऑन द ग्राउंड ऑफ इन्फ्रिंजमेंट बाय द FR और particularly Article 14 and Article 19 taking over the management of taking over the management of properties by the state, taking over the management of properties by the state, acquisition of state and related right by the state, acquisition of state and related right by the state, taking over the management of properties by the state, amalgamation of corporation, acquisition of estates हो गया and related right by the state, taking over the management of properties by the state, amalgamation of corporation, extinguishment or modification of right or director or shareholder of corporation, extinguishment or modification of mining leases. Article 31 does not immunize a state law from judicial review unless it has been reserved for the President's consideration and received his assent. This article also provides for the payment of compensation at market value when the state acquires a land held by a person under his personal cultivation. The land is within the statutory ceiling limit. And this article also provides for the payment of compensation at market value. Next is regulation of certain acts and regulation. Saving of laws providing for acquisition of state. Article 31B. Acquisition of estates and related right by the states. Saves the acts and regulation included in the 9th schedule from being challenged and invalidated on the ground of contravention of any of the fundamental right. Thus, the scope of Article 31B is wider than that of the Article 31A. Article 31B immunizes any law included in the 9th schedule from all the fundamental right, whether or not the law falls under any of the 5 categories specified in Article 31A. However, in a significant judgment delivered in IR Kohler case 2007, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the 9th schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th schedule. It said that the laws placed under the 9th schedule after April 24, 1973 are open to challenge in court. Laws placed under the 9th schedule after April 24, 1973 are open to it said that the laws placed under the 9th schedule after April 12, 1973 are open to challenge in court if they violated the fundamental rights guaranteed in Article 14, 15, 19 and 20. If they are open to challenge in court if they violate fundamental rights guaranteed under 14, 15, 19 or 21 or the basic structure of the Constitution. It was April 24, 1973 that the Supreme Court first propounded the doctrine of basic structure or basic feature of the Constitution in its landmark verdict in the Keshwan and the Bharti case. Originally, in 1951, the 9th schedule contained only 13 Act and regulation, but at present in 2016, the number is 282. These acts and regulation of the state legislature deal with land reform and abolition of the Mindari system, and Act of the Parliament deal with other matters. Next is League of Laws asserting against Article 31C as inserted by the 25th Amendment Act of 1971. Article 31C, it was inserted by the 25th Amendment Act of 1971. No law that seeks to implement the socialist directive principles specified in Article 39B or C shall be void in the ground of contravention of the fundamental right conferred by Article 40 or Article 19. No getting a declaration that is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the case of the Bharti case, the Supreme Court declared that above second provision in the Keshwan and the Bharti case. The Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground of judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. The 42nd Amendment Act of 1976 extended the scope of the above first provision of Article 31C by adding within its protection any law to implement any of the directive principles specified in Article 4 of the Constitution and not verily in Article 31B and C. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case 1998. Criticism of the fundamental right, therefore, enshrining part that of the Constitution are met with a wide and varied criticism. The argument of the critics are excessive limitation, there is a innumerable exception, restriction, qualification, explanation, as the critics among the Constitution grants FR with one hand and takes them with the other. takes a particle to 20 and 21 is another plot in the case of these right, the provision cuts at the root of democratic system in the country, replacing the right of the millions of innocent people in the continuous party. According to the critics of FR, should be enjoyable in all situations, expensive remedy. Rights outside part third of the Constitution. Rights outside, yeah, right outside part third. Besides the fundamental right included in part third, there are certain other rights containing other part of the Constitution. These rights are known as constitutional rights or legal rights. Besides the fundamental right included in part third, these are some rights contained in other part of the Constitution. Contained in the other part of the Constitution besides the FR included in part third, there are certain other rights contained in other part of the Constitution. These rights are known as the constitutional, legal rights, and non-fundamental rights. No tax shall be levied or collected except by the authority of law. Article 265 in Part 12 of the Constitution. No person shall be deprived of his property save by the authority of law. Article 308 in Part 12. Trade, commerce, and intercourse throughout the territory of India. Article 301. Even though the above rights are also equally justiciable, they are different from the fundamental right. In the case of violation of the above rights are also equally justiciable, they are different from fundamental right. In case of violation of FR, the aggrieved person can directly move for the Supreme Court under Article 32, which is in itself a fundamental right. But in case of violation of the above right, the aggrieved person cannot avail the constitutional remedy. He can move the High Court. He can move the High Court by an ordinary suitor under Article 226 with jurisdiction of the High Court. Minorities and martial law. Constitution, untouchable rights on them. Hello Seema, now you can ask your question. I will answer all your query over here. मैंने है ना अभी एक CAPF वीक 8 की वीडियो बनाई थी, उसमें मैंने अपने टारगेट्स मेंशन किए थे कि मैं 2 सब्जेक्ट्स पैरेलली कवर कर रही हूँ, डैट इज़ पॉलिटी एंड मॉडर्न हिस्ट्री. तो पॉलिटी के लिए मैंने बताया था कि मैंने पॉलिटी को कैसे अलग अलग ग्रुप्स में डिवाइड किया है. सो अकॉर्डिंग टू डैट मैं पॉलिटी कवर करती हूँ सुबह, और रेस्ट ऑफ द डे मैं मॉडर्न हिस्ट्री और करेंट अफेयर्स कवर करती हूँ. So I get my targets built by myself and follow those. I am following 2 current affairs sources. One is Vision Magazine, Vision IS Magazine, and the second is the magazine of CDS Journey. आंसरिंग टू द क्वेरीज ऑफ सीमा बिष्ट, मैंने आपको है ना ईमेल पे रिवर्ट किया था, शायद आपने देखा नहीं, और यू आर आस्किंग फॉर माई व्हाट्सएप नंबर. आई कैन नॉट गिव इट बिकॉज आई कैन नॉट मेक इट पब्लिक. कनेक्ट करना चाहते हो देन यू कैन कनेक्ट टू मी ऑन इंस्टाग्राम एंड आई विल डेफिनेटली रिप्लाई ओवर देयर. आप मुझे इंस्टाग्राम पे मैसेज करो, मैं वहाँ पे आपको रिप्लाई करूँगी. आई नो आपने मुझे मेल किया था, मैंने आपके मेल का रिवर्ट किया था, आप एक बार चेक करो जाके. आई थिंक दिस इज़ ऑल फॉर टुडे. अब कल मिलते हैं नेक्स्ट सेशन के लिए, और अगर कोई डाउट्स रहेंगे तो फिर उसी में पूछ लेना, मैं एंड में आंसर कर दूँगी. फॉर पेपर टू आई हैव मेड अ वीडियो ऑन पेपर टू रिसोर्सेज, जिसमें आप जाके फ्री यूट्यूब चैनल से अपना कंटेंट और फॉर्मेट्स पढ़ सकते हो. और फॉर पेपर टू आई एम प्रैक्टिसिंग बाय माई सेल्फ, और मैं किसी भी अभी कोचिंग इंस्टीट्यूट पर रिलाई नहीं कर रही हूँ, बिकॉज जो भी आर्टिकुलेशन होता है या फिर जो फॉर्मेट राइटिंग होती है, मतलब राइटिंग होती है ना फॉर्मेट एंड इन एक्चुअल दैट मैनर, वो तो आपको खुद से लिखने पे ही आएगी. तो इसीलिए आई विल फोकस मोर ऑन राइटिंग थिंग्स बाय माई ओन. यू आर नॉट एन इंस्टा यूज़र, तो फिर आप ऐसा करो कि आप मेल में एक साथ अपने सारे क्वेश्चंस लिख दो और मैं उसका रिप्लाई कर दूँगी. अगर जुलाई में एग्ज़ाम है तो डेफिनेटली आपके पास 2 महीने रिवीजन के लिए तो होने चाहिए. तो मई के मिड तक आपका पूरा सिलेबस कंप्लीट हो जाना चाहिए इन माय ओपिनियन, क्योंकि 2.5 मंथ वुड बी मोर देन इनफ फॉर रिविजन एंड प्रैक्टिस. आई एम नॉट मेकिंग नोट्स फॉर पेपर टू. मैंने अभी आपको बताया कि मैंने एक पेपर टू पे वीडियो लाई थी, तो आप वो जाके देख लो. और उसमें ना मैंने बहुत सारे चैनल्स के नाम बताए हैं जहाँ पर जाके आप फॉर्मेट और उनका कंटेंट देख सकते हो. और रही बात क्या बोलते हैं उसको, नोट्स की, और कंटेंट की, तो आप इतना कुछ पढ़ रहे हो. देखो आप बेसिक जो भी स्टैटिक सब्जेक्ट्स है वो सब पढ़ रहे हो, अलॉन्ग विद डैट आप करंट अफेयर्स पढ़ रहे हो, तो मुझे नहीं लगता कि आपके पास कंटेंट की कमी होगी. इट इज़ जस्ट वी आर वन स्टेप अवे फ्रॉम राइटिंग. तो फिर अपना फियर निकालो और लिखना स्टार्ट करो, कुछ भी लिखो. पहले टूटा फूटा लिखोगे, फिर अच्छा फ्रेम करके लिखने लगोगे, तो फिर अभी इधर उधर अपना दिमाग मत भटकाओ कि फ्रॉम वेयर वी हैव टू कलेक्ट द नोट्स. सबसे पहले आप अपने बेसिक्स क्लियर करो, फॉर्मेट देखो पेपर का, और PYQs पे डीप डाइव करो. कुछ टॉपर्स की कॉपीज़ आई डोंट नो अवेलेबल होती हैं नहीं, या फिर कुछ फॉर्म ऐसे नहीं होते हैं, आंसर्स होते हैं जो, आई एम नॉट गेटिंग द वर्ड, कुछ जो मॉडल आंसर्स होते हैं, आप है ना किसी भी कोचिंग इंस्टीट्यूट का चैनल ओपन कर लीजिए, उसमें वो फ्री रिसोर्स या फ्री इनिशिएटिव करके सेक्शन होता है, उसमें वो कुछ मॉडल आंसर्स प्रोवाइड करते हैं, तो आप उसे देखिए, उससे रेफरेंस लीजिए और खुद लिखना स्टार्ट कीजिए. ओके सीमा, हाउ टू कवर NCERT. रीड करो सिर्फ, मतलब फॉर एग्जांपल हिस्ट्री की आप पढ़ रहे हो, अगर थीम्स 1 2 3, तो ऐसा मत सोचो कि तीनों, मतलब एक टाइम लिमिट सेट कर दिया और तीनों को इतने टाइम में, सपोज एक वीक में कंप्लीट करना है, तो अगर टाइम प्रेशर के साथ कंप्लीट करने बैठोगे तब तो वो नहीं होने वाली है. सबसे पहले देखो कि व्हाट इज़ योर रीडिंग कैपेबिलिटी एंड हाउ लॉन्ग आप बैठ सकते हो, आपके सिटिंग आवर्स कितने हैं, तो उस बेसिस में आप अपने उस बुक को कुछ पार्ट्स में डिवाइड करो, मतलब चैप्टर्स में तो होती है, उन चैप्टर्स को भी छोटे छोटे पार्ट्स में डिवाइड करके फिर पढ़ो, तो आप ऐसे करके पूरी कवर कर लोगे। और है ना, PYQs देखते जाना साथ साथ में, ताकि आपको आइडिया मिले कि अ, मतलब कौन से टॉपिक से पर्टिकुलरली क्वेश्चन आता है, ताकि आप जो वेग इन्फॉर्मेशन होती है उस पर ज़्यादा फोकस ना करो, इंस्टेड जो यूजफुल इन्फॉर्मेशन है उस पर आप फोकस कर सको। Any more questions? Okay, so I am ending the live.